The Hindu Marriage Act 1955. Section 1. Short title and extent. Introduction. Marriage is sacrament. Marriage is necessarily the basis of social organization and the foundation of important legal rights and obligations. In Hindu law, marriage is treated as a samskara or a sacrament. Earlier, there were many different forms of marriage followed by the Hindus, and each being different from the other, and each form of marriage depicts a different stage of social progress. A stage had been reached when codification, at least of the law of marriage and succession, had become inevitable. Subsection 1 of Section 1 says that this act may be called the Hindu Marriage Act 1955 and received the President's assent on 18th of May 1955. Subsection 2 of Section 1 says that it extends to the whole of India and applies to Hindus domiciled in the territories to which this act extends who are outside the said territories. Domicile means the place where a person's or individual's habitation is fixed without any present intention of removing therefrom. Domicile. Let's consider that a person or an individual does not have a home, but he cannot be without domicile. In such circumstances, law considers his or her place of birth as domicile and is known as domicile of origin. Domicile of origin continues to adhere to an individual or prevails until a new domicile has been acquired. If a person or individual leaves the country of origin with an undoubted intention of never returning to it again, his domicile of origin adheres to him until he settles with the requisite intention in some other country. When there is absence of intention of settle down in a particular place, the domicile of origin is retained. When the intention of settling down in another country is not borne out from the facts, this act shall apply as the domicile would be that of India. Example of domicile. A person who has domicile of origin in India moves to England with an intention of never returning back to India, but he later leaves England with an intention of not returning and goes to United States of America, and yet he is uncertain as to in which part of the United States he has to settle, and dies while staying in a hotel in New York. He would be deemed to have died domiciled in India. In Sondur Gopal vs. Sondur Rajni, AIR 2013, SC 2678, wife files for judicial separation in India. Husband claiming that he and his family have acquired Australia as domicile of choice. The court held that residential tenancy document was for mere 18 months. Visa was only long-term work permit. Neither he nor his family acquired Australian citizenship. Hence, intention of residing permanently is not evident from material produced by husband. Claim of Australian domicile is not tenable. Husband and his family continues to be domicile of origin. It implies India. As such, he is continued to be governed by Hindu Marriage Act. Petition filed by wife is maintainable. Thanks to Slides Go.